All right, and sharing screen. Hopefully everyone can see. Let us know if we have any technical difficulties. So again, welcome to this webinar series. Obviously, it's extremely timely. There's a lot happening, and there's a lot that we need to consider and that we need to do in order to make sure that kids and students are adequately protected. So this is a collaboration between AASA, the School Superintendents Association, and Public Interest Privacy Center. I just founded Public Interest Privacy Center. I've been working in child and student privacy for about a decade now, and really wanted to continue providing resources and equipping people with information on these topics because they're not new. We're looking at so many of these issues, but they've popped up in states, in other countries over the past several years. And there are resources out there to help us to think more and more about them. And PIPC has partnered with AASA, the School Superintendents Association, which I believe is the oldest education membership association in the country, dating back to the 1800s. And we are working closely with them for their new Student and Child Privacy Center, which provides technical assistance and information to stakeholders throughout this process, but also specifically school superintendents. So today's agenda, we're going to start with me talking, as I said, not the most exciting part of today, but very excited to dig in on this. We're going to talk a bit about the panel. So we're going to have an expert panel digging in on specific questions here, and then we're going to dive into Q&A. So making sure that we get to some, if not all, of your questions. I have a feeling we're going to have many more questions than we can actually answer today. But that's why we have multiple webinars here, and we will be sending out information for everyone after this webinar. So let's talk about privacy. There's so much discussion about these issues, and oftentimes we don't start with a definition that everybody agrees on, because of course privacy is a really amorphous concept. But when we're talking about this, when we're thinking about this, I like to define privacy. This dates back to my time as a VP at Future Privacy Forum, as the responsible, ethical, and equitable collection, use, sharing, and protection of child and student data. Because there are all sorts of purposes for which we need to use student and child data. We need to consider what is most important to study, to help them with. A lot of times when we're having these conversations, we're basing it off of data collection, the CDC report, various studies that are showing us information about how technology affects children and students, but also how it can help them in so many ways. So we're going to be talking about privacy sort of in that context of data sharing, collection, use, protection, as opposed to not using data at all, but instead using it with guardrails around it. I also love to talk about what has been coming up more and more over the past several years, which is the idea of privacy as fairness and addressing power imbalances. So Friederike Kulthuner was at Privacy International, I believe, when she wrote this, said that privacy was once misconstrued as being about hiding and secrecy, but it's understood to be something much more pressing today, the power dynamics. And of course, when we're talking about kids, when we're talking about students, there are a lot of power dynamics between them and companies, between even them and their parents, certainly between the various entities who collect their data, often to help them, sometimes not for good purposes. And so we can think about privacy, in addition to the previous definition, as a potential way to address power imbalances. But why do kids need additional protections? I don't know if any of you tuned into the congressional hearing about a week and a half ago now, where I was able to talk a bit to subcommittee of House Energy and Commerce about why children need additional protections. So first and foremost, obviously their brains are not fully developed. There's a lack of experience, which means that they may end up trusting the wrong person, doing the wrong thing just because they don't have experience in what to do. They have a different conception of privacy. There have been amazing research studies, mostly by Sonia Livingstone, a researcher in the UK, about how kids are more likely to think about privacy in the context of privacy from their friends, privacy from their parents, privacy from their siblings, but not from a Google search or a company or their, the organization that runs their connected toy. So you also have this lack of thinking about some of the privacy concerns that we're worried most about today. And then there are potentially more acute harms, the mistakes, the thoughts, the issues that occur in childhood, and when even as children are teenagers, can affect them dramatically more in some cases than adults. But I would like to flag that kids need protections the day they turn 18, just as the day before 18. And so we need to make sure that we have privacy for everyone, and not just kids, but kids do deserve heightened protections. So some of the potential harms that I've seen in my decade often boil down to this. So I've heard from parents and school districts and state education agencies and policymakers and pretty much I think everyone at this point. And oftentimes the most common concerns, complaints boil down to these categories. So health and safety, concerns about things like mental health, particularly lately, but also, is a stranger or somebody dangerous able to communicate with my child or learn where my child lives? There are concerns about over collection and over surveillance. So how much information is being collected about my child or about me? A permanent record, and this is where you have a particularly potential acute harm for kids. Will mistakes be recorded forever? How long does this stick around? Relatedly, a loss of opportunity. What information, what dumb thing you do on the internet, what inaccurate thing may be showing up in a database that's used to determine which opportunities my child or I don't have access to. We also have major equity concerns. What if information is biased? What if it is used in an inequitable way? What if a parent and their child can't or don't have access to the information or technology needed to be able to do things in this day and age that would give them additional opportunities? What about age inappropriate content? How do we deal with inappropriate content? Social harm, this is a big one. Is my child being cyberbullied, stigmatized, otherwise harmed by various people on the internet or people in real life, stigmatizing them because of information about them? And then commercialization, this is the one I often hear most often, but definitely I think there is less discussion of the concrete harm from commercialization. So we're all concerned about companies potentially showing targeted advertisements, creating a profile, but often there's less worry about that exclusively showing a kid a targeted ad. It's often much more about these other risks, that idea that a profile created by a marketer, a company, could lead to this loss of opportunity, could lead to a permanent record, could lead to a database of information. And so, while commercialization definitely belongs on this list, I want to make sure that we're also thinking about the fact that many of the harms that we categorize there really have their most acute impact in some of these other categories. Responding to a question, yes, the slide deck will be posted online and we will send it out to all registrants after the event. But the challenge, which is enormous and difficult, how do we allow opportunities for youth online while mitigating risks? Because after all, there's so much that technology offers us. I can't imagine, and I don't know if any of you can imagine, a world where the internet didn't exist during the pandemic, where I think many of us had families that added some friction to our lives, where, you know, some people drew closer and other people were very happy to see people going back to work and school. But the nice part is, even though I think we all got sick of Zoom happy hours and Zoom meetups and Zoom meetings, we weren't alone. The internet gave us community, gave us education in a very concrete way, gave our children an opportunity to continue playing, continue working with other people during the pandemic. Not to mention, before the pandemic, all of these things were there as well. Technology offers us great opportunities for our children. And so thinking about how we can allow for those while protecting them is incredibly important and incredibly hard to do. So let's talk about some of the laws that exist. Family Educational Rights and Privacy Act, FERPA. This law was passed in 1974, and it guarantees parents and eligible students, generally those over 18, access to their child's educational records. It also allows privacy, so it prevents unauthorized disclosure of educational records without consent or very specific safeguards. I think this is information that's often missing. There are exceptions to consent in FERPA for reasons that I'll talk about in a little bit, but each of those exceptions is accompanied by specific rights or specific protections. However, FERPA today is often unclear and almost impossible for districts, for even experts, to navigate without significant assistance and time and digging through law and regulation and guidance and Federal Register and all sorts of documents, which poses a serious problem to actual implementation of privacy protections. We also have the Protection of People Rights Amendment. So this actually directly follows FERPA. It was created out of concern about really intrusion into the sanctity of the home or sanctity of the family, the sanctity of kids' thoughts. And this law, which also passed in 1974, it's been amended a couple of times, specifically restricted the questions or types of questions that students could be asked in a survey in school without parental opt-in or out. And I will say it has a few other provisions as well that are mostly confusing. So again, this is where we see a law with some really good protections and provisions but not a lot of ability to understand and apply the privacy protections that it provides. And then this is the part that I think is most shocking to people who haven't been involved in these conversations. Since 2013, 47 states, or I should say 46 states and DC, have passed over 130 laws. That's not a typo, not talking about bills. There's been well over 1,000 student privacy bills introduced in all 50 states over the past several years. This has been an incredibly active area. And part of the reason I bring this up and mention it is not only that kids spend a lot of their day in school, and so any discussion of child privacy needs to include a discussion of student privacy, but also because there's a lot that has been learned from the many laws. And as you can imagine, with 130 laws, some of those were fixing things and figuring out how to do this better, how to provide more protections. And many of those lessons can be applied as we work on child privacy right now. And these laws sort of fell into two categories. So one was based on FERPA, was specific to what schools were required to do, or any educational agency or institution. So posting which apps are being used online, going ahead and creating substantial data governance policies or vetting for ed tech, or additional transparency measures, restrictions in contracting. So that was sort of aimed at the school side. And then we had a bunch of laws that kicked off with California's PIPPA, which passed in California in 2014. And this law directly governed companies. So it said, okay, ed tech companies, you are working with schools, and it is important that you have a burden directly on you, not just indirectly through schools, to make sure you have certain privacy protections, to restrict or just ban targeted advertising, profiles of students, all of that. And so you saw sort of both this regulation of the public sector and the private sector playing out, and some marrying between the two, to the point where most states at this point have laws in both categories. And then COPPA. You know, you've all been waiting to hear about COPPA, Children's Online Privacy Protection Act, which passed over 20 years ago now. So anyone who remembers dial-up internet, Encyclopedia Britannica on floppy disk, will remember how very different the internet was at that point in time, but there was still the same concern that we have today about it. There was still a worry about what kids would access, the risks that kids would face. So COPPA only applies to operators of commercial websites and online services. Basically, if it is a company with a connection to the internet, you are potentially covered under COPPA. That site or service must be directed to children or have actual knowledge that kids under 13 are using the site. And companies subject to COPPA must obtain parental consent before collecting personal information from, not about, from a child, but in some circumstances, you may have a school consent, and there's a broad level of consent that is very complicated that I think we'll talk about a bit in our discussion, that is required here, that has often led to kids lying so they're able to skip this permission process. So what is happening? Right now, I'm just going to boil down what we're seeing to some lovely graphics. So we're having a conversation where we decide the relationship between kids and technology, between kids and the internet. And so there are proposals that in all of these situations pretty much are talking about cars. I don't know if anyone has had a bingo card yet of whether cars have come up at every privacy hearing, but I've certainly heard it at most. So there's a discussion of banning the car, not allowing kids to access technology at all until they're a certain age, or not accessing the internet at all, not accessing social media at all until they're a certain age. There's more of a bus approach, so only in the presence of other adults or something that's a little more facilitated. There's more of a driver's ed approach, both in generally teaching and actively hands-on. Here's how you deal with this. There's giving people directions, telling them, especially as they grow older, where to go and what to do and how to navigate all of this, as opposed to just banning it or restricting it until age 13, 16, 17, 18. And then there's also the approach that puts the onus on, in this metaphor, the car company. So it says, okay, cars need to have seat belts, need to have airbags, need to have additional protections when we're talking about kids. As I said, we're not going to dig into these proposals much right now since we're still focusing on the 101, but I wanted to give you a little bit of an idea of the types of protections that we're looking at. And finally, I also want to talk about how the school context is different. So one of the things that we've seen as consumer privacy laws have passed over the past few years, about 5 years now, is the question of when you give broad consumer rights, what does that mean when you're in a school context? Can you have a modern day Ferris Bueller asked to delete their attendance record or their test scores or the assignment they did last week, which is complicated. School is a different setting where there's certain information that needs to be turned over, that needs to be shared, such as, student medical information, in particular allergies. You have school photos, so you can always opt out of those. You have apps that are used as textbooks instead of, apps that are sort of used as the equivalent of a field trip. You have students' grades and other information about students. And then there's just ordinary things like people's addresses. How do you organize bus routes? How do you think about all of this? And so it's really important as we're having these conversations in child privacy to also consider this broader conversation, both about how we can learn from the student privacy work done over the past decade and how we can make sure that we're incorporating into what we're creating for children the specific constraints and considerations in the school context. So with that, I'm going to stop talking and I'm going to bring in our fabulous panelists. So there we go, getting up. And I'm going to go ahead and start by just handing it to them to introduce themselves and talk just really briefly about their backgrounds. So maybe starting with Rachel.
Sure. Thank you so much for having me, Amelia. I'm Rachel Anderson, Vice President at the Data Quality Campaign. I have worked in student data and student privacy specifically for over a decade at the Data Quality Campaign, and have really focused on the legal, policy, ethical, and technical aspects of student privacy. My work is housed within the Data Quality Campaign's larger efforts to ensure that data works for people as they move through the education and workforce systems. We believe that data should be a tool to help policymakers make better policy, to help education and workforce leaders make better programming decisions, and to help individuals make decisions for themselves. But as a part of that, we know that people are not going to use data that they don't trust is being protected and used ethically. So we always center privacy in our work with federal, state, and local leaders. So delighted to be here today. Thanks, Amelia.
Thank you. Passing things over to Olga.
Hi, thank you, Amelia. Thanks for having me. Olga Kaplan, I am here in my role as a parent advocate. I worry a lot about kids' privacy, particularly my children's, of course, but I have been working and looking at privacy for, I would say, over 10, 12 years in the student data environment. In my professional life, I work in the financial industry, and we worry a lot about security and technology and how data moves around the entire world as well. So focused on privacy there as well. Thank you.
Thanks so much for joining us. And Elana.
Hi, I'm Elana Zeide. I'm a professor at the University of Nebraska's College of Law. And my research and teaching focuses on student and child privacy, and in particular, the impact of emerging technologies on pedagogy, equality, and access and opportunity, including important new developments like AI in education.
Fantastic. Thank you so much for being here, all of you. I am very excited, both because this is such a fantastic panel, but also because all of these people are very dear friends, and I always learn from them. So very excited to put them in front of all of you. So with that, I think it's going to be really important to start today's conversation by maybe going back to something that I was talking about in the presentation. Why is protecting privacy so important, so vital to do? So with that, maybe Rachel, you had started talking about this a little. Do you want to take that first?
Yeah, absolutely. And as you're saying, you alluded to this in your opening remarks, that this is a topic that has had no shortage of legislative efforts and broader conversation. And honestly, that's quite understandable, because privacy touches so many different issues and has so many different components. It's technical, of course, there's a lot of legal considerations, but it also touches a lot of ethical decisions that we have to make. Our conversations about privacy often are really expressions of our values and of our worldviews, and the ways that we want to see schools and society more broadly serve children and families. So we certainly have seen a lot of state, local, and federal efforts to address data privacy in various ways, or to address the ethical use of data in various ways. And it hasn't always led to a very cohesive vision of what we're trying to do, but I think it certainly reflects the vast array of issues that make up the issue of privacy.
Fantastic. Olga, what about you? Why do you think there continues to be such extensive policymaking and interest in these issues?
Oh, you're muted, Olga. No.
Okay, there we go. My computer's acting up today, so my apologies. We have a lot of changing technology, right? Technology is constantly changing, and everybody wants the best and the brightest and whatnot for kids. But what keeps changing, the concerns are the same, right? Are we taking care of the kids? Are we protecting their data? But what is important to protect? What's important to release to other entities and individuals that can help in the education area? Those children, whether they have special needs or they're just super bright kids, it all matters. And that debate is always a heated one, because what is important for one parent to protect in terms of information for their kids might not be as important to somebody else. And then you have the actual users of this, the kids, and they are very opinionated on what they feel is important for people to know about them, whether it's in education or in whatever social media platforms they're in. But particularly in education, is what do the teachers know about them? What does the school official know about them? What are my parents getting to know? And I think that's why it's such a complicated topic, and why we keep talking about it and trying to make it better from everybody's perspective, which is can get a little thorny at times.
Absolutely. And Elana, why do you think this conversation continues again and again?
Well, parents have always been concerned about the effect of new technologies on their children, whether we're talking about the novel, the radio or TV, or social media. And that's really natural because it's untested, it's new, it's suspicious, it's different than how they did things when they grew up. And so, many parents quite rightly see the internet as a possible Wild West where anything could happen to their children. The children could be exposed to anything. They see sometimes their children are being, guinea pigs. And it's high stakes. Parents care about their children's development as humans. There are opportunities that might be impacted by data that's collected by them. So it makes sense. And also because, as anyone who's in the audience probably is aware, people like to save the children, right? It's very compelling message, and it often gets bipartisan support. Sometimes it's not because people are quite talking about the same thing, but it really is a motivating rally cry.
Absolutely. I think we've seen that with so many of the op-eds and conversations, including those in State of the Union and in congressional hearings, talking about, obviously we need privacy protections in general, but especially kids. It's very important. So I know when working on these issues, I found that even, some of the smartest, savviest people I know who don't focus in depth on this work can believe inaccurate information. So my eternal soapbox is how necessary it is for us to ensure we're always starting these discussions with accurate information so that we then can solve the specific problems. So for example, there's the never-ending myth that student privacy laws at both federal and state levels allow ed tech companies to sell student data, which is not the case, but because these laws often haven't been publicly enforced, people assume that there aren't laws at all, and the solution is passing more laws. What are some misconceptions that you think are important to clarify as we start this conversation? Rachel, maybe starting with you.
Sure. Two things immediately come to mind, one a little bit more practical, one a little bit more philosophical. I think practically speaking, state agency leaders especially, and local leaders as well, just don't have clarity about what is permissive under state and federal laws. A lot of the work that state leaders often want to do, like giving data to high school seniors about how different colleges may help them reach different careers, or helping state policymakers understand what happens to their high school graduates after they leave, or how their state preschool program is doing in preparing students for success in K-12. All of these uses of data by states are completely permissible, but states often don't have clarity from federal leaders that this is the case. So I think a lot of misconceptions come from just a lot of different legal interpretations of code and policy that really should be more clear. And I think coming up a level from that, a misconception I often see is this sort of false choice between data use and privacy. This idea that we have to either choose that students can have privacy, or we can use data to help them succeed and help our schools improve. And that's truly just a false choice. There are policy and legal ways to really truly protect students' privacy and to make sure that data is being used in transparent and ethical ways that don't require us to stop getting the benefit of data. The truth is that we can mitigate a lot of privacy risks, but we really can't mitigate the risk of not using data, of casting aside this incredibly powerful tool that could help us address inequities, improve outcomes in education and the workforce. I mean, not using data is a real risk. The risk of privacy, we can take real concerted steps to address.
Absolutely. Elana.
So I think some of the misconceptions are, one is, as Rachel mentioned, people are not quite clear about what the law is, what's permitted under the law, what's not, which often leads to, well, it leads to one of two things. One, it often leads to companies or schools being overprotective, saying, I'm not sure, so I'm just going to, dial up my protections to 10 and hope that's okay. And that can sometimes make it unwieldy to use data. And so important things get shut down. Also, there's often pushes for rights or protections that already exist in the current law, but people are just not aware of them. So those are the two ones I see that are perhaps most important.
Great. And Olga, how about you?
Well, I think a lot of parents think that it's a free fall of data, right? If a school or an organization is allowed to collect the data, anybody can see it, anybody can do whatever they want. And it can also be commercialized, and my kid's going to get targeted, and I don't even know where information is going. I think that's the biggest misconception. Once you start to drill down and you look at what is allowable, what is not, what schools actually do with that information, obviously that's different. But on the surface, it's like, if I let somebody get that information from my kid, everybody's going to have access to it.
So that's actually a perfect segue to our next question, because of course there are a number of harms and violations of kids' privacy that do come up that maybe aren't talked about quite as much as some of these myths. So Olga, what are some examples of times that you feel your children's privacy was violated, either because the law wasn't understood or followed, or because there aren't legal protections in place?
Yeah, so, and I wrote a little bit about this a while ago, and it was really interesting because in sports, and it's still a school sport, it's a school team, and it's regulated, and it has to be under all these rules that the kids have to follow because it's part of the high school team. The kids join the high school team, and the great solution to be able to communicate between each other and the coaches was to have the kids join the Facebook page for the team. Now, it was a great idea because everybody's on Facebook, according to them, but it was a sanctioned school team that had to fall under certain protections, right? So my kid immediately looked at me because, they're all, influenced by my thinking and teachings. And he's like, what do I do? I don't really feel comfortable doing this, but if he didn't, then he wouldn't join the team, right? So I think that that's an issue, is the teachers, the coaches not understanding that maybe that mode of communication was not the best, and maybe there's other venues to communicate with the kids than just an open public Facebook page. And sometimes, they think, well, if the kids are using Google and Google Classroom, well, Google Classroom has different protections than an open Facebook page would for students, right? So that was interesting. And what was really interesting was listening to the kids that didn't want to join it to say, I don't want to do this as a kid, as a student, say, I don't really want to join Facebook, because kids are really savvy about that. So that was interesting. Another interesting thing that happened to my kids was also, when you sign off the FERPA permission slip at the beginning of the year, and you have a kid that is in high school and wants to get into certain college programs, but you are either all in or all out, right? Can the school release certain athletic information or academic information with your name and your picture? And if you have a kid that's really high achieving and wants people to know that about them, and you say no, then they can't, right? So now you're limiting opportunities that could come to them in that way. So I think those are the two, which was a struggle for us to say, how much do we want to release about you so that you can have these opportunities, but if we don't, then you don't have them, right? It's an all or nothing approach, which I think we really need to look at and discuss. And it's a lot more nuanced than just saying yes or no and off we go.
Absolutely. Elana, this gives me an opportunity to pass to you. There's a lot of proposals that have parental consent at the center of them, or teen consent at the center of them. Can you talk a little bit about the pros and cons of consent as an approach for protecting privacy?
So consent is very appealing, right? So who would be against giving parents or children control over their information? It's often actually a definition people have when you ask them about what privacy means. And it sounds great, but you all don't read terms of service. And truthfully, neither do I as a privacy professor, because it's not rational. The policies are unclear, vague, legalese, they change, so you're supposed to check back and update them. Or you have privacy controls put in place, which are about 12 different options and buttons for every single app one might use. This is placing an untenable burden on parents. It's making them do what is called privacy work, and no one can really keep up with that amount of things. But parents in particular end up feeling bad, like, oh, I'm not doing enough to protect my child. But the system is kind of rigged so that they really can't do that. So, so bills or measures that really promote parental consent often just end up defaulting to either like, okay, someone uses something or they don't use it. There's very little nuance, even though they're supposed to be there to purportedly create more flexibility for parents and students. But it rarely, again, leads to meaningful informed consent, especially if people don't have many other options to choose from. Most people don't want to forego opportunities or change the schools their children go to just based on their privacy concerns, right? So that's a big part of the problem, in that it really ends up being ineffectual and more just like handing off. It's also it's impossible to expect parents to predict what the consequences of sharing data will be and what will happen to that data, and more importantly, what that information will reveal later on. To give you an example, maybe about 10 years ago, parents who posted pictures of their children on Facebook or let other post the pictures on Facebook that were privacy, cared about their children's privacy, would let people tag their children, meaning wouldn't sort of associate their name with the picture. Well, Facebook has since developed facial recognition, which means that picture is now identifiable, connected with people's names, even if at the beginning, parents permitted that because they thought that the names were more obscure, that it wouldn't be linked specifically to their children. You can't expect that people will predict things like that. So it's an appealing tool. It sounds great, but in practice, it's often quite ineffectual and leaves parents, I think, feeling more helpless than empowered.
So, Olga, as a parent, what do you think are the most important issues for policymakers to tackle to protect your children's privacy? What are things to keep in mind, especially, as we are all buried in consent, but we want underlying protections for kids?
So the biggest thing for me as a parent is don't go too far. Data matters and data works, and it is very helpful. So when thinking about protections, it doesn't mean take it all away. As a parent, is please allow that good data to be shared, because there is value in it and it does help the kids in their educational journey. So be mindful and pragmatic when you're looking at how you're going to protect kids. As Elana said, we all want to, save the kids, but in saving them, we might harm them by not allowing certain information or certain applications to be used.
Rachel, I think you and I are maybe one of 5 people who have read most of the student privacy legislation that's been introduced in the past decade. What are some lessons learned from what worked, what didn't work, what was changed because it wasn't working when those student privacy laws were passed?
Yeah, that's a great question because we have, as you said in your opening, seen so many hundreds of state efforts over the last decade or so to really protect student privacy in different ways. And we have seen states take a number of different approaches. The 4 sort of components of a privacy law that I think have been most effective for states, without getting into the really, really specific pieces that we've seen, are governance, continually updated policies, supports for people in districts, and clear communication about how data is used and protected. And I think most important of all for states and federal policymakers to consider is establishing broader data governance that really captures and articulates how decisions about data collection, protection, sharing, and use are made, even larger than specific privacy issues.
Rachel, can you describe a couple examples of what is meant by data governance? Because I think for folks outside of the world of privacy and data, it's often a new term.
Yeah, or I think a term that is used so broadly that it lacks almost any meaning. Ideally, a state should have data governance that is a standalone body, an entity that is established in law and that exists independent of any particular state agency. This entity should be empowered to bring together leadership level representatives from all state agencies that contribute data to a state's data system, as well as hopefully additional stakeholders like parents, members of the public, researchers. And together, this entity, this governance body, is charged with making decisions about why the state is bringing together data from across agencies in the first place, what uses are allowed, what the goals are, what's prioritized, and as part of this, what the privacy and access rules are. This is a hugely important part of strong data governance, is creating the policies and overseeing the technical infrastructure that ensures that data is protected and kept secure.
Thank you. So this is the point when we're going to start to open things up for Q&A. So please go ahead and put your questions in. But we'll start with Elana. There's been a lot of concern around how algorithms and AI in general impacts kids. As someone who has significant expertise in the intersection of AI and students, children, marginalized groups in particular, what do policymakers need to know?
So the most important thing to know is AI is new. It is flawed, right? And it is not a magic cure. And Amelia's laughing. But however, I could give you example over example of times where entities, particularly schools, have adopted AI-based tools, not realizing, not even having evidence of whether they're effective, and not knowing the ways they could go wrong, so that they couldn't put oversight or protective mechanisms in place, and not being able to train the people using them to deploy them responsibly. So for example, most AI is based on historical patterns, data that was created under conditions that were very unequal. So anything the data patterns show, therefore reflect those biases and inequalities. You may have heard about this when there's a lot of discussion, for example, about how facial recognition is poor at recognizing the darker skinned faces or female faces, right? You get this in what words are associated with certain images when you do a Google search. So this is particularly important because if you are relying on these tools to make decisions or recommendations, they will simply replicate the biases of the past and entrench existing technologies. But if you are going to adopt them, it's important to then have ways to teach people, say, okay, well, this is how this could go wrong. These are the things you should look for. When you see these things, you should be skeptical. what the AI is telling you, and to make sure, please make sure that someone somewhere has evidence showing these things actually work. Companies are very reluctant to share that information, and people get their hopes up, but many times it just quite isn't there. Online proctoring is a real example of this.
Great, thank you so much, Elana. I have a question about, let's see, I think Olga. We've been seeing a lot of proposals around restricting access to social media, proving your age, limiting access to the internet. How practical are these approaches? What do you want to protect your kids from? And what do you think will work in protecting them outside of the school context?
Yeah, kids will always find a way, right? And asking them to check that I'm 13 box on the website is not enough. So I would say legislation and laws and whatnot are not going to prevent kids from finding a way. I think where we need to look at is how are organizations and these companies going to protect my kid? And that is how we look at it, is from that angle. Are we allowing them, how are we allowing them to use certain data if they're going to access it? Obviously, you can put certain kid filters on whatever if they're younger, but as they get older, they will have their iPhone and they'll move around and download certain apps that you are not even aware of. But how are those apps using that data they're collecting, and how are we regulating those organizations as opposed to trying to regulate the kid who will find a way to log in?
Absolutely. I think I was really amused because we saw South Korea actually have sort of what was called the Cinderella law, because after midnight, you couldn't game if you were, I think it was under 16 or 17 in the country. And apparently kids were just figured out how to use VPNs to come into the country from another country, and just were really creative in making sure that they got access to what they wanted. So as we close out our panel today, first of all, thank you all for attending, but what are the takeaways from today's discussion, or things we haven't discussed yet that you want policymakers to consider as they craft and improve child and student privacy laws and regulations? And Olga, maybe starting with you.
Sure, thank you. I mean, to me, it's be aware of the consequences that are going to come with certain legislation, right? Sometimes good intentions can create harm, and how is that going to impact kids with special needs, kids from low-income families, kids that need educational support? If you have certain legislation that prevents you to access data that will help those kids, then we're harming those kids more than helping them.
Thank you so much, Olga. Rachel, what do you want people to take away?
I would ask federal policymakers especially to consider three things in their role in protecting student privacy. One would be to work to update and create a foundation of laws that states can build from, that are really clear about the ways that data can and should be used to support young people as they move through the education system. And then as part of that, secondarily, federal policymakers have a really important role in helping state leaders understand how different federal laws interact with each other. It would be incredibly useful to have some joint guidance between, say, Ed and the FTC on how COPPA should be interpreted in and out of schools, or between Ed and the Department of Labor about how WIOA data can be shared and used to understand the impact of different education programs. So creating that base of really strong laws, putting out guidance about how all of these laws interact, and then also importantly, helping state and local leaders build their capacity to use data ethically and effectively, and to implement all of these privacy protections. As Elana was saying, so much of our our approach to privacy is really about pushing some sort of interpretation or responsibility onto the individual who often just doesn't have the bandwidth to really dive into these issues. And that's very much true for district leaders as well. So it's really important that federal leaders help states and districts implement data laws as well.
Thank you. So we're at the top of the hour. So Elana, I'm going to give you the final word here. Thank you to everybody who is attending. We will send out the recording and materials, but Elana, what is our takeaway or a couple of takeaways to leave people with?
I think for me, the main takeaway is to be really concrete when you consider writing laws about what harms you're trying to address and how the specific things you're proposing might address those, and if there are enough resources or if it's practically administratable. Often I think, in the enthusiasm to protect children, very broad strokes are passed. And again, they don't always lead to the consequences that policymakers intend. So just be very nuanced and concrete when you're trying to put new laws into place.
That is the perfect note to end on. So thank you all so much. Our panelists, thank you for indulging in this conversation today. Thank you all for attending. On behalf of both ASA and PIPC and ASA's Student and Child Privacy Center, honored to have you spend some time with us. So with that, you'll receive more materials soon. Thank you so much.